attending this press conference. My name is Eric Kardal, K-A-A-R-D-A-L, and this is Anmarie Calgaro, my client. And we're going to organize the press conference of a series of speakers, myself introducing the lawsuit, and then Anmarie is going to speak, and then Michelle Lentz, representing the Child Protection League, is going to speak, then Mr. Breccia, and then Representative Len Grunhagen, so you won't be surprised. The lawsuit that we're filing right now in the U.S. District Court is a federal due process clause claim. And what Anmarie is the mother of a minor child who, without her consent and without court order, has been able to get government funding for an elective medical procedure from Park Nicollet to change his identity, JDK's identity, from boy to girl. In the statute in play, Chapter 144, it's cited in the complaint that I've distributed, it's 144.341, allows medical service providers to determine emancipation without reference to parental consent or court order. That's very important to understand. This is a controversial law that was passed in 1971, and in 2003 and 2004, the House tried to repeal this law under the Parental Health Access Act. So the idea here is that one side has said we're not going to have parental notice and opportunity to be heard, and the other side has, and the statute still exists. So medical service providers determine whether a teenage child is emancipated, and then can get these non-emergency elective medical services. And Anmarie's upset about it. She still communicates with her son, but she doesn't have any right in court. So if you'd imagine, Minnesota has statutes that codify due process procedures in marital dissolution, in child protection, and in paternity cases. But this is the emancipation subject area, and there's no statutory procedures to protect the parental rights. Now, on the judicial website, you'll see that the court says if you're a teenager, you can file a common law petition for emancipation. Well, that's fine. But here, JDK didn't need that court petition for emancipation because the governmental agencies here, the school district, the county, other state agencies, just treat him as emancipated anyway. So if there had been a court order of emancipation, then Anmarie would have received notice and opportunity to be heard. But here, because of the way the county operates, the way the state operates, the way the school district operates, the way the medical providers operate, Anmarie doesn't have any right to notice and to be heard in court. So how does that operate practically? Well, Anmarie has been shut out of all educational and medical decisions for a child and can't even get information from the medical service providers, the county, or the school district about her child. That's all without a court order. So the statute that I mentioned doesn't provide a process for Anmarie even after the deprivation of her parental rights to go to court. Now the common law, that's the ancient common law, provides her child an opportunity to petition for emancipation. But of course the ancient common law doesn't recognize Anmarie's right to petition to de-emancipate the child. You see the asymmetry there. The common law is old, and the common law has been around for a long time, and the child can petition for emancipation under the common law, but there's no common law right for a parent to come back and de-emancipate the child. So the statute is unconstitutional in its application to Anmarie because it doesn't provide a procedure that when the medical service providers in the county decide to treat the child as emancipated, for Anmarie to file a petition in the court. She is not getting her day in court. This lawsuit isn't about, in a sense, the parental rights themselves. It's about a day in court to defend the parental rights. And that's huge. And in Minnesota, we're a very conscientious state, and when it comes to petitions for emancipation, the courts say right out in the opinions, well, emancipation for teenagers, that can be conditional, it can be partial, it can be temporary. So what the judges are saying is, we want to take care of the best interest of that child. But how does that happen when there's no court procedure at all? Anmarie has lost complete control of her teenage son without any court proceedings, any court hearings. And because of Minnesota statutes and common law, she can't even go to state court. If she went to state court, there's no claim. She can't do anything. So what we need is a federal court decision saying that Anmarie's federal due process rights have been violated, because her parental rights are a fundamental rights protected under the U.S. Constitution, and she's entitled to a hearing prior to her parental rights being terminated by the county, the medical service providers, and the school district. I'll be available for more questions, but now I'd like to introduce my client, Ms. Calgaro.
Hi, my name is Anmarie Calgaro, ANMARIE-CALGARO. Last year, without my knowledge or consent, without any court hearings or legal process, without any involvement on my part whatsoever, a legal aid group that gives free services to low-income people created a notice of emancipation for my 15-year-old son. Suddenly, my son, without any notice to me, was no longer under my supervision. Based on that piece of paper alone, he began receiving public assistance, including medical services and housing and food support. The St. Louis County Health and Human Services treated him as an adult. I couldn't get any information regarding my son. Even the school refused to allow me access to his records. It was then brought to my knowledge that my son had begun receiving hormone replacement treatments from Nicollet Health Services to transition from male to female with medical assistance paying for this. Excuse me. I was not consulted or informed about this in any way. I had no way to give or receive any information about my son. Since then, Fairview Health Services of Hibbing has also prescribed narcotics to my son. I am forbidden to be involved with his very important health needs. The news that county agencies and health service providers, the school and other county and state offices were completely bypassing me came as a complete and total shock. Why wasn't I even notified? I believe that my constitutional civil right to have my case heard in a court of law has been stripped from me. If this had been a child custody case, I would have had my day in court. If my son were to be placed in foster care, I would have had my day in court. Or if he had been referred to child protection, I would have had my day in court. I am firmly committed to what is best for my son. I am his mother, and he has always been and always will be welcome in our home. He has 3 older siblings and 3 younger siblings whom still live in the home, not the older siblings. And we all love him beyond words and care very, very deeply about his well-being. As a mother, I know his emotional and physical needs in a way no one else can. I also have a commitment to him that no one else has. And I feel not only was I robbed of the opportunity to help and guide my son make good decisions, but I also feel that he was robbed of a key advocate in his life, his mother. I'm taking this action today so that the courts will recognize my due process rights under the United States Constitution. And so for that the good of my son, the courts will restore my parental rights. I'm also taking this action for the benefit of all parents and families who may be facing the same violation of their rights, so that they and others in the future may be spared from the same tragic events. Thank you.
And now I'd like to introduce Michelle Lentz. She's a representative of the Child Protection League.
Thank you, Eric. My name is Michelle Lentz. I'm the president of the Child Protection League, MICHELELENTZ. The Child Protection League exists to protect children from indoctrination, exploitation, and violence. CPL is eager to support Anmarie Calgaro in her legal challenge to the grievous assault on her parental due process civil rights protected by the 14th Amendment to the U.S. Constitution. We're grateful that she's willing to take this bold step because she gives voice to the countless parents and families across the country that are being similarly harmed. St. Louis County Public Health and Human Services, Nicollet Health Services, Fairview Health Services of Hibbing, and the St. Louis County School District have essentially eliminated Ms. Calgaro's parental rights based on nothing more than a statement of emancipation issued by the Free Services of a Legal Aid Group and without any court order. These entities are treating this now 17-year-old minor as if he is an adult. They are financing and prescribing dangerous hormonal drugs and prescription narcotics to a minor without his mother's knowledge, involvement, or consent. She is blocked from even viewing his health and school records. For his safety and for his welfare, Ms. Calgaro wants and needs to be involved in the ongoing medical care and education of her child. She is denied any avenue to plead her case in court. Children are too often being used as pawns for the financial and political designs of special interest groups, groups that cannot have the level of regard for the personal, long-term well-being of a child as does a parent. Government agencies and healthcare providers should be protective buffers for minors. They should never be a party to violating the rights of a parent to oversee the needs of her child. The decisions underage children make about themselves often have permanent consequences that will affect their relationships, their families, their health, and their emotional stability. And yet, the very person who knows, loves, and is most deeply committed to her child is being excluded from providing for him at this hour of his greatest need. Few values are more sacred and more deeply regarded than the nurturing bond of a loving parent-child relationship. Disregarding and trampling that bond severely harms children and families. CPL urges the court to declare that Ms. Calgaro's due process rights under the U.S. Constitution have been violated and to issue an injunction restoring her full parental rights under her due process until her due process rights have been restored. We encourage, support, and defend Ms. Calgaro's courageous lawsuit. She deserves everyone's respect, admiration, and support. It may have enormous implications for all families and children. Thank you.
I'm pleased to announce that we have a special guest for the press conference today. Coming from Chicago just for this press conference is Tom Breccia, President and General Counsel of the Thomas More Society, a public interest law firm.
Well, thank you, Eric. Our Thomas More Society is a national public interest law firm. We are pleased, honored to support Anmarie Calgaro and to work with Eric Cardahl here. He's an excellent lawyer. We're here to help him, back him up, and press this case until justice is achieved. And that's really all I have to say. Thank you. We're in this for the long haul.
And our final speaker, and then we'll take questions, is Representative Glenn Grunehagen.
I'm State Rep Glenn Grunehagen, and let me get my notes here. As an elected official, I am deeply concerned when I see state agencies, healthcare services, and other organizations undermine parental authority. I intend to introduce legislation to strengthen parental authority over their children and to make sure that it cannot be undermined or negated without due legal process. This would include addressing the current emancipation statute in the state of Minnesota. Thank you.
All the speakers are available for questions, but I'll moderate the questions. Are there questions for any of the speakers?
How often does a case like this come up? Is this a one-off case, or does this happen every day?
Prior to, I'll answer with respect to the medical services component.
Can you repeat the question?
The bulk of the lawsuit, the question is, how often does this happen? And we're going to be talking about the medical services component broadly. And it happens every day, according to the medical expert that I talked to. I'm not going to divulge his name, but I talked to a top medical doctor. We paid him. We want to know what was going on in the medical community. And the understanding in the medical community is that this statute means that whether a teenager is emancipated when they present themselves for services, and we're basically talking here about non-emergency services, that determination is made at the front desk. So basically, if the child can pay for the services, that means the doctors, the medical service providers treat them as emancipated. So here the sequence is, the teenager goes to the county with the letter from the legal aid clinic, and the legal aid clinic is taking the position the kid's emancipated. The teenager then gets the eligibility from the county to fund living independently, then goes to the doctor and says, look, I'm eligible for these benefits and insurance, and then the medical services are provided. So this happens every day in Minnesota, and the concern here from Anmarie's perspective is that in these procedures where the county's involved, the medical service providers are involved, and I didn't mention the school district's also involved, also the Department of Motor Vehicles, though not a defendant in the case, they're kind of involved. All these things happen as if the child's emancipated when there's been no notice and opportunity heard for the parents. And so this is about having a day in court. And the reason why this law was challenged, I believe, back in 2003, 2004 by the House repealing these provisions, then it did pass the Senate, is exactly this issue. And so this is not a new issue for Minnesota. It's been around. And whether there needs to be parental consent when teenagers want to get non-emergency medical services. And my client's position, at least with the severity here of this huge decision, changing from being a boy to a girl through the hormonal therapies and what other medical procedures are required, she believes that she should have gotten notice and opportunity to be heard, either before the services commenced or even after the services commenced. The fancy legal terms are, well, if you don't get a pre-deprivation hearing, pre-termination hearing, you should get a post-termination hearing. And when Anmarie talked to several attorneys before me, and they basically told her, there's nothing you can do. And so what I'm saying is, well, there's nothing that a lawyer can do in state court, so you have to go to federal court to find that her procedural rights are being violated because she can't go to state court and assert her parental rights. Are there further questions?
Yeah, are these legal services marketing to these kids? How are these kids finding out these legal services? I wouldn't think this would be a known thing that's happening.
Yeah, if you go to the judicial website and you look under help topics, then you find that the Minnesota Judicial Department is saying to teenagers that you can petition to be emancipated, and then you should contact this legal aid clinic, and then the teenagers go contact that legal aid clinic. Then what they do is they provide this emancipation letter based on the child's allegations. So if you can imagine, this legal aid clinic interviews and then just produces a letter without talking to the parent. And then the state agencies, in this case, are relying on that letter for the emancipation. And so those lawyers are not due process for the parent. They're facilitating emancipation without court orders, and that's what we're opposed. We think that just like in the marital dissolution, paternity and child protection areas where the procedures are codified, that those procedures need to exist under the U.S. Constitution. So another way to put it is, the way that we know Minnesota cares about due process rights for parents prior to termination of parental rights is that Minnesota has codified, put in statute, a procedural due process for parents prior to termination of parental rights in those three subject areas of marital dissolution, paternity, and child protection. So, in answer to the question, kind of going back to, does this happen a lot? Well, we're talking about emancipation. Is emancipation, are there as many emancipated teenagers as there are children involved in marital dissolution proceedings? No. But I would tell you that if in a marital dissolution proceeding, If we were terminating rights, honestly, terminating rights of parents without notifying the parents, you would all be horrified. I mean, you think about that. You have marital dissolution proceeding, and there's a hearing about the child's welfare, and the parents aren't invited. Right, and that's what's happening here, is that Anmarie isn't invited to these administrative hearings or whatever processes you have at the county and in the school district, and also the statutory process that's being followed by the medical providers. She's not invited. She's not welcome. So it's all one-sided. Are there further questions?
Anmarie, I have to ask, why does your son want to be emancipated, and how long has he, I'm assuming, not been living with you?
Well, I would assume I asked him to wait until he was 18 to make any major decisions with his life. Just, hang on and just, let time play out here and just wait until you're 18 to go about, changing your name or your identity. And he was eager to have that done. That would be my honest answer.
And while you're there, I assume you have custody. It's not like there's a divorce in somebody else's custody. So nobody in the family was notified of any of this?
Nothing.
Okay.
When will your child be 18?
He will be 18 coming in July. So this all started when he was 15. And it's been a really long process because we went through 3 different attorneys before, I was directed towards Eric. And so it's been a very long process. We were hoping to have some things resolved long before, but just with hopes to stop these elective medical treatments at least until he finished puberty and that sort of thing.
Do you anticipate a decision on this before July?
I can't answer that honestly.
Yeah, Anmarie has other minor children as well, and so we anticipate this is for July, and we don't anticipate the case becoming moot in July either. Every parent rights are at stake with respect to Anmarie. She has additional minor children younger than JDK, so the case won't be rendered moot.
What kind of a process actually happened? Is there some sort of a hearing or anything, or did he just fill out a questionnaire and they said okay, or?
Yeah, that's a great question. There's so at the Mid-Minnesota Legal Aid Clinic, it's referenced in and I think actually in the complaint, if you have one, Mid-Minnesota Legal Aid letter is Exhibit A, and so they went through some questions, and then they said, and it's, in our view, legally dubious, that he was emancipated. Then he went to the medical service provider, and the medical service providers were relying on the statute that I mentioned that says that medical service providers can provide, once determining the child's emancipated, can provide medical services, and then went to the school district and did a similar thing. Now, the school district doesn't have a statute. They're just winging it, I guess. And so then that's kind of what happened, but Anmarie never got notice. What she got was, I'm not going to provide you any information. She would call and she'd write, I'm not going to provide you any involvement in your son's decisions. And so it was done without any, court process or even administrative process. And so what our point basically is that, you go talk to lawyers when this happens in Minnesota, and they're actually right that they can't do anything for Anmarie. And so and here's the little asymmetry, and I know this is technical and legal, but it wasn't obvious to me when I started. It took a long time to get to this position. But the asymmetry is the background of the law is the common law. And so the common law recognizes that the teenager can bring a petition for emancipation, as shown on the Minnesota judicial website. But when you have a statute that says the medical service providers can emancipate for medical decisions without a provision for her to have notice and opportunity to be heard, the common law doesn't save you because the common law is set. That there's no right at common law for her to petition the court to de-emancipate the child. And so the statute must provide a provision for her, at least post-deprivation, after it's done, in a sense, to establish her parental rights again. And it doesn't mean that the parent wins. Again, in Minnesota, the courts have always taken this view, it's always about the best interest of the child, but that doesn't mean there aren't parental rights too. And so that has to be balanced in the process. So that's why I mentioned in the Minnesota Supreme Court cases regarding emancipation can be partial, conditional, or temporary. And that's what we expect in a lot of these cases, particularly as the child approaches 18. And your question?
Yeah, so what happens when it goes, if it goes in Anmarie's favor? I mean, what happens then? Are you going to stop his transitioning? Are you going, what's the plan?
Yeah, it's a great question. Because we're moving on an as-applied basis, the remedies we seek only apply to Anmarie and her family. And so what would happen would be that the medical service providers, the school district, and the county would have to stop acting as if he's emancipated. In every situation, parental consent would be required until, two things, right? One, Anmarie's provided an opportunity to litigate in state court the issues. Or two, a JDK goes to court and gets a court order of emancipation. I want to go back to the question just quickly. One of the oddities here, and why I kind of woke up to the claim and the process, and it wasn't a long process studying this, that JDK sought a name change in Stearns County and in St. Louis County. And so this kind of shows how contradictory right now the system is. So he was able to get the medical consent for these life-changing treatments, but then when it came to a name change in both those counties, the judges said, you don't have a court order of emancipation and you haven't given notice to your parents. And so they said, no, you can't change your name. So that's what the court's saying. And then the administrative agencies here, the school district and the county, and then also the medical service providers are saying you're emancipated. So there's a contradiction. Now, it doesn't mean that we can't live with contradictions, but here, because the parental rights are recognized as fundamental liberty interests under the 14th Amendment, we have to pay attention to procedural due process, and that's why the lawsuit makes a tremendous amount of sense. And even I want to talk about the medical expert that I talked to. I think he was about 70, and he had been in the profession a long time, and he said, the medical community is unified on this, Eric. Because I had to hire an expert before I filed this, because I couldn't believe this is the way it worked. And he said, this is the way it works. And then he said, but as a parent, I understand you have a point. And so when we're here, and we all of us probably know medical service providers, and you ask them, does it really work that way? They're going to tell you yes, and then they're going to agree, well, yeah, the parent has a point. There should be some process, at least after the emancipation decision's made, to be heard.
Yeah, so how is it different from a teenager going to get an STD check or going to a therapist and saying, I want you to not tell my parents, what we talk about or my results or something like that, versus what we're dealing with now? Yeah,
there are situations like that were addressed when this law was enacted in 1971 and then when it wasn't repealed in 2003, 2004. And those are some of the policy reasons given for not requiring consent. In fact, they even mentioned in the one of the reports that I saw of the 2003 repealer was that this idea of requiring consent for medical services would cost $11 million to the state of Minnesota. But the point is, you could say the same thing about eliminating parental due process in all child custody contexts. So the point being, we are willing to pay to have due process for parents before their parental rights are terminated. So in that case, there might be an extra step required of getting a court order or parental consent before providing services. And yeah, it is an extra step, and it does cost money. But our view is parental rights are important. The sponsors of the law obviously thought they were less important than we do.
Is Minnesota unusual in its approach? How do we compare to other states?
The research that we've looked at is that other states do have emancipation statutes that do have the due process procedures, but I have to get back to you on that. I didn't do the research.
Just if you could clarify for me, exactly what are you asking for?
We're asking the court to enjoin the defendants from acting as if this teenage child is emancipated until there's a court order of emancipation or Anmarie provided a process in state court to resolve the emancipation issue. And so, yeah, it's technical, but that comes with the territory of procedural due process claims.
And then, so you are dangerous to this child. Well, there are tons of kids that are going through transitioning in the United States. Dangerous to who? I mean, to me it sounded a little objective because there's kids that are now using hormones. So when you say that they're dangerous, I mean, isn't that what the medical field is for, to properly give those hormones to children who are transitioning?
Yeah, I think that, I guess Anmarie can probably speak to that as to her view. I don't have a view on that. Anmarie, get that?
Well, first of all, I can say that, nobody, even at 20 years old, would go back and make the same decisions as they would at 16. No, I mean, I can't imagine any of you in this room would go back and go, yeah, I was proud of that moment in my life. So, by dangerous, and I'm not the one who stated that, but I have an opinion on that, is that I've done a lot of research in this because I care so deeply for my son. I want to be involved in this process. Is that I've learned that for those kids transitioning, if he changes his mind in the future, and not that he will, and that's not what this is even about, but to answer your question, is that if he did change his mind and he wanted to have a family of his own, some of the side effects of these hormone replacements are that he would become sterile and he would not be able to have a family of his own. And I guess, with the FDA, they do a lot of research on the certain medications that are prescribed, but I think that was lacking in this sort of area of the medical field. And so he himself has described to me that the hormone replacement has caused him to feel suicidal, that it's causing him to feel very crazy at times. And the doctor reiterated to him, that's perfectly normal. You're like a little girl going through puberty is what they told him. And they also told him that the best time to do this is now, before you are completed with puberty, which I disagree. I'm not saying he should be one way or the other. I'm not pushing that. I love him unconditionally, and I mean that unconditionally. I just wanted him to slow down and let himself develop naturally and see if he still felt the same way at 18 when he is a legal adult as he did at 15. And so that's the best that I can do.
How does he feel? How does he feel about this?
He knows about this. We've asked him to be a part of it, and his only fear was that he would lose his treatments. He understands it completely. He agrees, Mom, you should have had a day in court. He agrees with that. And he also agrees that he received bad legal advice, but he also says, well, it's working. So, I mean, a typical 16-year-old response, I think. So, yeah, I think that I think that he's experiencing confusion from all over, not just this one thing. I think that when we went through puberty, I think we were all a little bit kind of crazy and confused, but, yeah, that's
Where does he live?
He's got his own apartment.
How long has he had his own apartment?
It's probably been, I'd have to look at my notes, 6 months, something like that. We've helped him get furniture for, I don't approve of him living on his own, but when I went to visit him, I'm kind of like, well, you need some stuff here, So we got him some furniture and some dishes and things like that. So I love him, and at his apartment it was all white walls. There's nothing. I'm like, this kind of, except for the padded walls here, we really need to get you some life in this apartment. So we're working on doing that. I have family members who have helped get stuff for him just to help him.
And he's been out since he was 15, or out of the house since?
No, he was 15. Yes, he went to live with his dad. His dad and I are not together. We have two boys together, and because he's very intelligent. My son JDK is extremely intelligent. I would not deny that on any level. He excels very much in academics, and with what he was going through, he wanted to go to a different school. He wanted where there was more educational opportunities for him. And after some lengthy discussions and agreements, I agreed to let him go live with his dad. And in that process, this all sort of took place, and Dad moved, and he was kind of...
Did his father have any part in this, or in him becoming whatever kind of emancipated he is? Or?
He very much objects to this, and he's in agreement with me that we should at least have our side of it heard. I mean, I can't imagine taking anybody's one side of the story. We should always be seeking to find, I always say that there's her side and there's his side, and then somewhere in the middle is the truth, right? Because we're all persuaded by our own perception of what we believe and how we feel. And so he disagrees that we should have been heard.
Since you've been involved in this, have you talked to other parents in similar situations?
I'm not finding anybody in a similar situation, but I do talk to other parents. I'm very involved in the community. And with the transitioning thing put aside, because that's not even the issue. The issue is that he's able to just go make these decisions, and then, well, what stops anybody else's child from doing the same thing? Maybe somebody wants to go get emancipated because mom says you can't have a tattoo, but they want a tattoo. You know what I'm saying? And so they agree very strongly and are fearful that this could happen to them, regardless of what their child may be going through.
Representative, as a former school board member, which I've heard you say a few thousand times, have you seen examples of something like this happening in schools? Do they consider a student emancipated without a court order?
Yeah, repetition is the key to learning. That's why I repeat that so often. I'll give a school board member. There's certain incidences. I don't want to go into specifics, but I haven't seen specifically an emancipation letter, but there is sometimes referrals for medical treatment without parental notification, and that is a concern. That was a concern of mine when I was on the school board, and it continues to be as a legislator. Again, I don't like to see the undermining of parental authority without any type of due process legal procedure. So, and that's, I guess, the root of the situation.
Have you seen, I guess what I call an elective medical procedure, like whether it's this or something else, happen without an emancipation order, court order?
No, I haven't.
And Eric, I have another question for you. Has a similar case come up in federal court, since that's what you're looking at here, and if so, how did it turn out?
No, we haven't found this particular fact pattern. And I think the distinguishable facts are just the major non-emergency elective surgery statute doesn't require parental notice and consent, and the common law not providing the parent an opportunity to petition to get the rights back. I did want to mention that the Mid-Minnesota Legal Aid Clinic Letter is Exhibit A. B is the St. Louis County court order, which was a response to an earlier question, which states that you can't change your name because you don't have a court order of emancipation. So again, the court's recognizing that notice and opportunity to be heard is required for the parents prior to emancipation. And then C is the letter from Park Nicollet Gender Services, which was presented by JDK in support of the petition in St. Louis County to change the name. So that's how we got it. And so that letter is from Dr. Julie Farias of Park Nicollet Minneapolis Gender Services, indicating that the treatments are being provided. And so I just wanted to mention that those exhibits are included. Are there any further questions?
And to be clear, besides the gender change, did I understand, I think you said that the county has authorized payment to help him live by himself?
That's right. The county determined that he was emancipated, meaning that he was eligible for the programs. So, for example, how the insurance works is if Anmarie had a chance, she would have said, well, he's covered under my insurance policy. The government should cover it. And then, of course, her consent would be required for the services. And so here, the county, by making JDK eligible for benefits like medical services, has enabled Fairview and Park Nicollet to provide these services that she objects to all without a court order. And so, it's almost like, I was talking to Mr. Brecky about this, it's almost like, okay, he goes to the county says, well, you're independent, you get all this money, and then everyone else acts as if he's independent. But the county never provided notice and opportunity to be heard for the parent. And again, the result in an emancipation proceeding can be that you're emancipated conditionally, partially, temporarily. And so you can have the judge kind of make these distinctions, which are made every day in the context of child custody disputes.
Where's the medical expert from? Is he from this?
Yeah, he was from Minnesota.
Okay.
So, and are there any further questions?
Filed in St. Paul or Minneapolis?
And
U.S. North.
we're filing electronically, and so the U.S. District Court, I guess the division would be completely right. Yeah, but it's the one district in Minnesota and the different divisions.
So that's where the hearings likely would be.
Before the magistrate judge, that's an excellent point. That's likely to be up there.
In regards to this lawsuit, has there been any precedents that would either hinder or help this particular lawsuit?
Well, I kind of did the less is more thing before, so I'm going to respond to this in the greater way. So, yeah, I mean, all the cases say that parental rights are fundamental rights under the U.S. Constitution, the liberty interest in the 14th Amendment. The 14th Amendment says liberty can't be deprived without due process of law. So all the cases say that prior to termination of parental rights, a parent has a right to be notified and opportunity to be heard. Now here, because of the non-emergency aspect of the medical services being provided, we can even say we don't get a hearing after the deprivation. So it's been announced that by the medical service providers, others, that he's emancipated, we can't get the information, can't be involved, that there still isn't a process even after deprivation to go to state court. So yeah, all the case law runs in our favor, and the statute that we're talking about is constitutionally effective because it doesn't have a procedure for a parent to go to state court like that. Any other questions? Thank you for coming. I really appreciate it.
Thank you.